My name's Jennifer Carson. I'm the managing partner of CMBG3 Law in Boston. We are a majority women-owned law firm with 3 offices and nationwide reach. We help clients in litigation, litigation management, compliance, and government affairs. I'm here today to welcome all of you and thank you for joining us for this very special event. This is the second in what will be a series of webinars, which our legal and government affairs teams cover hot topics alongside some very, very special guests. We hope that you enjoy today's event. Follow us on social media and look out for the next event that we're hosting. And with that, I'm going to turn it over to our very talented and quite exceptional moderator, Chanel Brown, who is the director of CMBG3's Government Affairs Division. Take it away.
Thank you, Jen. Hello, everyone. My name is Chanel Brown, and I'm delighted to be here with you all today to moderate this important discussion. For our expert panel, we have my colleague, Eric Roby, an associate attorney and the co-chair of our firm's COVID-19 legal task force. We are also joined by 2 special guests, Ryan Stifter, who is a forensic economist at RU, and Massachusetts State Senator Jamie Eldridge. Senator Eldridge happens to be the lead sponsor of legislation to require that insurers provide business interruption coverage for COVID-19 related claims. Mr. Roby will begin our discussion today by providing us with an overview of business interruption insurance, highlighting the recent rise in coverage litigation and addressing the key issues that litigants face in coverage disputes. Next, we will turn to Senator Eldridge for a discussion about how states and the federal government are addressing this issue. We will also talk specifically about the legislation he filed. Following that discussion will be Mr. Stifter, who will talk to us about valuation of business interruption claims and what policyholders and insurers should be doing now to avoid issues and ensure an accurate and efficient resolution of claims. We will then open up the floor for some live Q&A. I will note that we are pleased to see that our attendees today represent stakeholders on both sides of this issue, as well as press outlets. Therefore, we are sure to have a lively and substantive debate. We hope you stay to the end. Now, without further ado, I will turn to Mr. Roby.
Thank you, Chanel. Hello, everyone. My name is Eric Roby. Today, I'm going to talk to you about business interruption insurance and give you an overview of the kind of coverages that are provided. We're going to discuss key issues in coverage litigation. We're going to look at how courts have addressed similar issues in the past, and we're going to discuss what those issues might mean as we move forward with COVID-19 litigation. But first, of course, I have to give the basic disclaimer that this is for information purposes only and does not constitute legal advice. We're going to look at some exemplar policy language today, mostly from the Insurance Services Office, but each policy is different and the needs of each policy need to be independently analyzed. And we are happy to do so here. So if that's something you're interested in, please feel free to contact our office. So let's dive right in and start with the basic question: what is business interruption insurance? This is a kind of insurance typically found in commercial property policies, also found in some other packaged business policies. And this covers losses resulting from the interruption of a policyholder's business due to a covered event or a covered peril. And it's ultimately designed to put the policyholder back in the same position they would be in if this event or if this loss had not occurred. So there are 3 elements to it. The first is that the loss must occur as a result of a suspension of the business. The suspension must be caused by direct physical loss or damage or similar language. And it must result from a covered cause of loss. This raises a point about 2 different kinds of policies that you'll find this in. First is an all-risk policy, which covers all risks unless they're otherwise excluded. On the other side is a covered perils policy, which only covers named perils. We'll talk a little bit more about the litigation later, but what we're seeing is a lot of coverage disputes, primarily in the all risks insurance department. Similarly, there's a time period with respect to this coverage called a period of restoration, and Ryan is going to speak to this a little bit later. And we're going to focus a lot today on this particular clause here, direct physical loss or damage, which is shaping up to be a major issue in coverage litigation of business interruption insurance. What losses are covered? Business income means the loss of your net profits, so pre-tax, as well as your operating expenses. And as with any policy, there is a duty to mitigate losses. So that requires a coverage called extra expense insurance. Extra expense covers those costs that policyholders incur in mitigation efforts. Similarly, the language once again indicates this direct physical loss or damage concept. So we're going to continually see this throughout business interruption basic coverage, extra expenses coverage, and you'll see this continually with other kinds of coverages relating to business interruption. We're going to look at contingent business interruption, and contingent business interruption covers losses incurred when the event that causes the interruption occurs somewhere other than your insured property. So in this other properties, if your business depends upon, for example, a key supplier or a customer's facility. And this particular contingent property may be named, so your policy may say this particular supplier, or maybe more generalized. An important concept with contingent business interruption is that the losses are measured slightly differently. Only losses explicitly relating to the particular loss are covered. So by way of example, if you're a product manufacturer who makes multiple products, and one of your suppliers for one of your products suffers some kind of a damage, a fire to their warehouse, for example, your loss is limited to the impact on that particular product that you can no longer make because of your supplier issues. The loss does not cover any other business interruption relating to your other products. So contingent business interruption is more narrowly focused on those specific kinds of damages. Relatedly, civil authority coverage is provided in these policies, and this is coverage for losses caused by the actions of civil authorities that prohibit access to the insured's property. So the order of civil authority first must limit access. The access must be resulting from a direct physical loss occurring other than the insured property. This must result from a covered cause of loss, and that loss has to lead to a result from prohibited access. So an example is a water main breaks down the street, and the civil authority shuts off access to all of the restaurants on a particular, all the properties on a particular block. Even though your particular property has not suffered the loss itself, there is physical loss or damage in the area resulting in a civil authority order that prohibits access to your premises. Similarly, the concept of a direct physical loss is going to come into play. The language that you're seeing here on this screen from the Insurance Services Office actually does not contain the term direct physical loss, and it leaves me to wonder whether there will be some litigation about this issue in the future. So this question, the primary question, does COVID-19 cause direct physical loss or damage? You'll see there being a split in the courts. There's a more strict interpretation and a more liberal interpretation. The strict interpretation looks at alterations to the physical structure. So the classic example is, a restaurant is damaged in a hurricane. The more liberal interpretation looks to the use or the habitability of the property rather than its structure itself. And we'll see this play out explicitly in COVID-19 litigation. So let's take a look at some cases. The first is a strict interpretation case called Universal Image Productions. And this is a production company whose property had mold damage, but there was no tangible alteration to the structure itself. And the court asked the question, was there direct physical loss, thus triggering the policy? The court held that in the absence of tangible damage, there was no direct physical loss. And in an interesting and poignant footnote, the court stated that basic cleaning does not constitute this kind of tangible loss that is necessary to trigger coverage. So it raises questions about cleaning with the COVID-19 pandemic and whether simple cleaning measures may indicate that COVID-19 is a tangible or direct physical loss. Similarly, another case is called Columbia Knit v. Affiliated FM. This is a Portland, Oregon clothing manufacturer. They suffered mold damage to some fabric and some clothing, but not all, and made a claim for the entirety of their property, alleging that mold in the building generally was a direct physical loss. The court interestingly said they must look at the nature and the intended use of the property as part of their consideration. So here, clothing is the insured property, not the building itself. And the court indicated that the damage needs to be distinct and demonstrable, and that surface contamination without actual damage itself is insufficient. So it followed the same line as the prior case. And there are a variety of cases that fall into this category involving dust from a nearby construction project, mold in the room where the insured was a piece of particular equipment that was not damaged, exterior wood siding. These are some examples of things that did not cause structural damage to the insured property. On the flip side is some of the cases with liberal interpretation. The first we'll look at is Masner v. Seco, a Massachusetts case from my home jurisdiction. And this case involves carbon monoxide from a chimney, which was found to be direct physical loss or damage. And the court in this case, in an issue of first impression, cited favorably to a 1968 Colorado case, Western Fire v. First Presbyterian. And in that case involved a gas leak into the soil underneath and surrounding the church. And the First Presbyterian Court found that the church itself was uninhabitable as a result of this contamination, and that the lack of habitability equated to a direct physical loss. So the Massachusetts case, in relying on the same premise stated in First Presbyterian, found that there was carbon monoxide rendered the property uninhabitable, and therefore was a direct physical loss. Similarly, Sentinel Management Company versus New Hampshire Insurance is a case involving asbestos contamination. The contamination in the ambient air rendered the building uninhabitable, and once again, the court cited First Presbyterian and found that a direct physical loss does not require structural damage. The court focused instead on the building's function and found that contamination impacting the building's function could be a direct physical loss. You can see the thread here. Again, there's similar cases that continue this thread. Another asbestos case, a case where well water was contaminated by E. coli, resulting in a loss of utility or the function being eliminated or destroyed. There was a really interesting case involving an odor from a carpet installation or from sulfuric gas. You can see we're now dividing the courts into two camps with a liberal and strict interpretation of what constitutes physical loss or damage. I think one issue we're going to see going forward is proof problems, how to demonstrate actual contamination. The cases that we've looked at all had provable contamination. There was mold, there was E. coli, but something I foresee in COVID-19 is whether there was actual contamination given the lack of testing. Similarly, if there's inadequate testing or insufficient means to obtain testing, how can a policyholder comply with this proof element in their policy? Is it possible they may be able to raise the impossibility doctrine to escape that obligation? Interestingly, there is some litigation out there that talks a little bit about this and finds that there is actual contamination when there's a positive diagnosis of a person in the building or in the local community. Similarly, there may be habitability issues with respect to the liberal interpretation. If a business is operating at a reduced capacity, but not complete closure, and has access to their building, is it uninhabitable? And this has actually come up in a recent case filing where the insurer responded to a complaint stating exactly that their operations of a restaurant moved to a takeout nature of business rather than an in-service nature of business. So they're still using and occupying the property, and that it's not uninhabitable. So you'll see a lot of this going forward. Relatedly, do COVID-19 closure orders trigger civil authority coverage? The weight of authority seems to indicate that civil authority coverage requires direct physical loss or damage to the property. So take the water main break example that I stated earlier. But what happens when the policy does not use that terminology? There's one case that we have that seems to be the one that many plaintiffs are citing, that called the Allen Park Theater case. This arose out of the MLK assassination, and in order to prevent civil unrest, the mayor of Detroit issued a closure of businesses, including the plaintiff's theater. The court in that case found that this was a trigger of civil authority coverage because it lacked that term physical damage. And the court stated if they wanted to include that, it had to say so unequivocally. So we may see some of this moving forward. There's been significant jurisprudence arising out of the September 11th terrorist attacks, raising a few issues. The first is the rationale underlying the government order. In one case, the Pentagon was struck and an order grounded all planes. United Airlines sued, and the court found that the rationale underlying the order was based on the fear of further attacks, not on property damage. Similarly, did the government orders completely prohibit access? This is what we were just talking about with the habitability argument. Similarly, was the government's order preemptive? Hurricane Katrina case found that an order that pre-existed the landfall of Hurricane Katrina did not trigger the coverage. So are preventative measures that states and municipalities are putting in place sufficient to trigger this coverage? These are going to be issues we'll see in litigation moving forward. Of course, we have to talk about policy exclusions, and in particular, the virus exclusion. In mid-2006, following the SARS outbreak, the Insurance Services Office issued a new form endorsement, the exclusion of loss due to virus or bacteria. And this endorsement excludes any virus, bacteria, or microorganism that induces physical distress or illness. And the policy, this particular language was issued with a circular by the ISO, and the circular pretty much states that the specter of a pandemic is what they were thinking of when they issued this, and that it clarifies what they believe was the intent of the contamination provisions under these policies that pre-existed this specific exclusion. Their take was that these have been covered the whole time, and this is simply clarifying, and that any efforts to find virus or bacteria coverage was contrary to policy intent. Another exclusion that we have to take a look at is the ordinance or law exclusion, which essentially states that any losses suffered from a compliance with an ordinance or law are not covered. And so it includes the use of property. And thinking about that in the COVID-19 context, closure orders impact the use of property. Once again, the question is, does direct physical loss have a bearing? Case law seems to suggest that the actual damages must relate to the order themselves. So for example, if a fire in one part of the building damages a piece of the building, but the other part is operable. In one case, a bagel operator was, the local authority issued an order to evacuate the building. The bagel operator went out of business, and the court found coverage because fire was a covered loss. The fire ultimately resulted in the civil order. Therefore, it was a covered part of the policy, and coverage was extended. Other cases, such as this Dupree v. Allstate case, require physical damage, which some cases don't touch on that requirement. So let's take a look at some current trends in litigation. What we're seeing right now is a lot of case-by-case, state-by-state basis actions, the basis of which are breach of contract and declaratory. We're seeing a lot of these cases seeking consolidation into class actions. We have at least 2 proposed MDLs at this current moment. And interestingly, a direct petition to a state high court. This is the case of Tambellini v. Erie Insurance that I'll discuss briefly later. One thing else that we're seeing too is insurance broker suits. I've seen at least one case out there where, in addition to seeking a declaratory statement on coverage, there's also a second claim against the insurance broker for professional negligence. And this sort of relates to the notice of the virus exclusion. Is it the broker's duty to provide notice of the exclusion if the insurer provided the broker with such notice? Some of these issues we're going to see in litigation moving forward. So what comes next? Well, we're not stopping the claims, denials, and lawsuits. These are going to keep coming forward, especially in the near term. And it's my belief that we're going to see contingent business interruption claims as sort of the second wave. Right now, people are focusing on their own house. As orders ease and businesses begin to slowly come back, people are going to realize the impact on their supply chain. And I believe a second wave of contingent business interruption claims is likely. We're going to see continued efforts to consolidate either into class actions or MDLs. We're going to have some issues here where the insurers are arguing that each policy is individualized, has specific terms. Each government's order or government's mandate may be different. The petitioners have been arguing that these are all common issues relating to physical property or damage in the policies, and that clarification on these issues would have a broad sweeping effect. So we're gonna have to pay attention to see how this comes out. We're gonna continue to get a hodgepodge of legal rulings. Cases are gonna move slowly. And this is not gonna stop litigation relating to other coverage issues or litigation relating to claims issues such as valuation. And insurers, of course, are going to attempt to write pandemic policies in the future, and there's going to be a demand for those, although there's some challenges given the scale and magnitude of the current pandemic we're facing. So what am I watching for? Nationally, I'm watching for rulings on these key issues in various cases, in particular, the proof of loss issue. I'm particularly curious about those. Locally, Legal Seafoods has filed the first Massachusetts case relating to business interruption insurance. I'm particularly interested in this Tambellini emergency petition to the Pennsylvania Supreme Court. The MDL petitions that they'll be hearing in Boston on July 30th. There's also the United Kingdom's Financial Conduct Authority is seeking a July hearing for similar issues. There's a very unique novel case called SCGM. This particular case involves an actual pandemic endorsement, including 25 diseases, of which SARS-CoV-1 from back in the early 2000s, that SARS pandemic is included. The argument that petitioners are making in this case is that the coronavirus, the current crisis, is a variation of that SARS illness, therefore should be swept into coverage. It's a unique issue that I'm keeping an eye on. And finally, I'm also keeping an eye on the government action, legislative and executive. There's a lot of moving parts here, and that's going to clearly have an impact on what happens in the courts. So our final takeaway is that we're really sailing in uncharted waters, and we're heading straight for the storm that is the future of coverage and claims litigation resulting from this pandemic. We're only at the beginning of it now, and we're about to head into it. So we'll sort of see what happens. But clearly, there's a lot of issues at play. And I thank you for your time today, and I'll turn it back over to our moderator, Chanel. Thank you.
Thank you, Eric. That was great. And what your analysis suggests is that for businesses that desperately need to help, the litigation route might not be the best option for them. Which of course brings us to our next segment where we discuss legislative solutions with Senator Eldridge. However, before diving into a discussion with the Senator, I'd like to offer our audience some context about what's happening nationally in terms of business interruption insurance legislative initiatives. So what we have is that we're finding a series of bills being filed. It began in New Jersey in mid-March, and then it's continued. So since the first filing in New Jersey in mid-March regarding business interruption insurance legislation, we have seen more than about a dozen actually emerge in 7 additional states, including right here in Massachusetts. And so interestingly, the activity at the state level has emerged to bubble up and get national attention, and the president has even weighed in on this issue.
Well, it's something that we've already suggested. We're talking to them. Business interruption insurance. I'd like to see these insurance companies. You know, you have people that have paid. When I was in private, I had business interruption. When my business was interrupted through a hurricane or whatever it may be, I'd have business where I had it. I didn't always have it. Sometimes I had it. Sometimes I have a lot of different companies. But if I had it, I'd expect to be paid. You have people, I speak mostly to the restaurateurs, where they have a restaurant. They've been paying for 25, 30, 35 years, business interruption. They've never needed it. All of a sudden they need it. And I'm very good at reading language. I did very well in these subjects, okay? And I don't see the word pandemic mentioned. Now, in some cases it is. It's an exclusion. But in a lot of cases, I don't see it. I don't see reference, and they don't want to pay up. I would like to see the insurance companies pay if they need to pay, if it's fair. And they know what's fair, and I know what's fair. I can tell you very quickly. But business interruption insurance, that's getting a lot of money to a lot of people. And they've been paying for years. You know, sometimes they just started paying. But you have people that have never asked for business interruption insurance, and they've been paying a lot of money for a lot of years for the privilege of having it. And then when they finally need it, the insurance company says, we're not going to give it. We can't let that happen.
And in response, we have Senate Republicans sending him a letter indicating that he needs to stop it and to just hold off And they obviously make a few protests indicating that this actually may result in the insurance industry becoming insolvent. And so we haven't heard much from him since then. However, on the congressional side, we are seeing activity after his statements. We've seen at least two bills filed, one by a Democrat, one by a Republican. However, both of these bills, interestingly, are looking forward. They're looking about how do we avoid this controversy from happening in the future, rather than addressing the question of should insurers be required to cover claims that are being disputed today. So the question now is, where does this leave us? You know, we still have a lot of businesses that are out there that are concerned about how they're going to continue to be viable. And we haven't had a solution, even though we have several bills that have been filed across the country and continue to be filed. So that brings us to our next portion, which we engage Senator Eldridge. Our hope is that maybe with the senator's help, we can come away with a little bit more insights and direction in terms of where this is all going. So thank you, Senator Eldridge, for being here. We really appreciate it. We're honored to have you. And our audience is definitely excited to hear from you. So can you please help us understand your bill and why you filed it?
Absolutely. Well, thank you so much, Chanel, and thank you so much to being on the CMBG3 webinar and all the other presenters, and really highlight the complexities we're dealing with, which I think it's important to highlight that the goal here is to make sure that everyone stays whole. So that's businesses, especially restaurants that had to close down due to the COVID-19 pandemic, which employs thousands of people across Massachusetts and of course even more across the country. But also recognizing that we don't want to make insurance companies insolvent. And so the legislation that I filed, which is Senate 2655, an act concerning business interruption insurance, I actually came to file with an attorney from Sharon and Lodgen in Boston that represents a number of restaurants throughout Greater Boston that was already hearing from restaurants saying that they weren't really sure if they were going to be able to recover financially due to the pandemic. And certainly the district I represent, which is a Metro West district, I've heard from a number, especially of the independent smaller restaurants, saying that they weren't sure if they were going to be able to reopen, that they weren't able to pay their employees. And I think it's important to realize is that although some of the employees and some of the businesses benefited from the Federal CARES Act, a lot of people were left out. And so a lot of people are really financially struggling. And so the bill that I filed, which right now is in the Joint Committee on Financial Services in the legislature, would essentially repeal the so-called virus exclusion that was established as a rule, which Eric had mentioned back in 2007, that said that business interruption insurance does not cover viruses, including perhaps the coronavirus. And so what that means is that if a business has been shut down as a result of the coronavirus, or in this case, the executive order by Governor Baker, that claims from paying the wages for the employees, to rent, to a whole variety of bills that small businesses have, would not be covered by the insurance company. And so the bill that I have filed would require insurance companies to cover those claims, but it proposes to fund that by saying that the insurance companies can then turn around and submit for reimbursement those claims from the state government, and then post-pandemic, so after the pandemic is over, the Division of Insurance would assess the entire insurance industry to sort of spread the cost of paying these claims to recoup that money that was given out to through the insurance companies to small businesses. So at least in my mind, it's sort of modeled after some of the bank bailouts that happened after the 2008 recession. Is the federal government providing money to corporations so that they don't go bankrupt, but then, eventually getting that money back. So I do feel that it's a common sense proposal. I've certainly heard concerns, from the insurance industry that it would, make them insolvent. And, I'm certainly sensitive to that. But I really want to emphasize that, people are hurting now. We need to find a way to provide financial support to the business owners and their employees. But also, many of these businesses are saying that, they're not sure if they're going to be able to come back. And, one of the points I've made to a lot of insurance companies is that if you have a whole swath of small business owners, especially restaurants, that never reopened, those are going to be premiums that those insurance companies will no longer receive. So I think in the end, I'm hoping to build some consensus behind this legislation. As you had noted, this legislation did begin in New Jersey. I'm proud to have filed the second bill in the country here in Massachusetts. And as you've noted from the map you presented, there's been a number of other states that have presented this. There is a push at the federal government level to somehow include this as a reimbursement in one of the next versions of the stimulus bill. So that would be great to see, but I do think there's a place for state action here.
So one of the things you tried to explain was the financial mechanism of it. And I think that is something that we could maybe pay a little bit more attention to, because we did get a lot of questions in that regard, like exactly how it would work. One question was concerning when would people have to pay the assessments. And you did lay out that it would be post-pandemic versus before, or immediately after. But specifically, what are you hearing in terms from insurance companies, big and small, about those assessments? Have you seen any openness to this, or have you received pushback?
So far, I've just seen opposition from the insurance industry, and I get that. I'm just hoping they can take a look at sort of the format of the bill that I filed, which again would allow insurance companies to apply for reimbursement from state government, and then later on there would be an assessment not just on policyholders for business interruption insurance, but the entire insurance industry.
What businesses exactly would this apply to? Is there a limit in terms of the size of the business, in terms of how we're defining small?
Yeah, the language of the bill would be for any business that has 150 or fewer employees. And one of the questions I have received from restaurants who have, a number of chains or a company that owns a number of restaurants is, would this bill, if it became law, would it cover all of my restaurants or businesses? My view on the bill is that it's 150 employees or less per location. So, if an owner owns, 4 restaurants and there are 70 employees at each restaurant, that this coverage, this bill would cover all of those restaurants or businesses.
Okay.
As always, I think this, I'm open for any changes to the bill to make it as comprehensive as possible.
Would there be, just thinking about making sure that people stay employed, had you thought about any provisions to make sure that people that are able to get this, to recover these claims, are required to keep their employees on staff?
Yeah, that's a great question. And I think it highlights a real disadvantage that a lot of restaurants have, is that because the pandemic in many ways hit restaurants earlier, because people just stopped going to restaurants, before Governor Baker's executive order on March 10th, is that the Paycheck Protection Program and the CARES Act, says that a company has to keep their employees. And if a restaurant already laid off their employees, in some cases that doesn't make them eligible to apply for funding from the PPP. So it certainly would be my hope that the restaurants would be, in making their claims, paying their employees. And that's a typical claim for, other types of business interruption, but certainly open to making that more explicit in the bill.
I'd be remiss if I didn't mention that, some are challenging that bills of this kind are unconstitutional, violating a contracts clause. Do you have any position on that and why you think this bill is indeed constitutional and just for this cost?
Well, I think it's important to realize that, whether people like it or not, legislatures, whether federal or state, our focus is on public policy. And there are certainly examples in our country's history where public policy trumps, specific contract law. So I do think this is a reasonable public policy to require business interruption coverage applies when there are viruses. But, I certainly recognize that that's one of the legal challenges to getting this bill, passed and perhaps not challenged. But I just think, again, responding to, my constituents and businesses across the state, it really needs to be a way to provide relief to them. And I think this is one of the ways that can be done.
Thank you, Senator. Really appreciate your comments here and your insights. So now I'm going to transition to our next panelist, but I'd like you to stay just so we can have a few question and answers right after this next panelist.
All right, thank you, Chanel and Senator and Eric. Appreciate being here today. And thank you, CMBG3, for putting this on. In large part, I want to put a diagram up to sort of help you visualize what these losses actually look like when you have to put a value on them if covered claims go forward. So what you're really trying to do is ascertain the business's hypothetical profit had there not been whatever the covered loss ends up being. In the case of straightforward claims, is a direct physical loss. And then you're comparing that to the actual income, if any, that the business generated over that period of restoration that Eric had mentioned. So that's the rectangle on this diagram. It's a pretty simplistic picture. Now, COVID-19 doesn't really change this basic framework. In the large part, what we're seeing is the period of, the real impact of some of these civil authority actions that have been taken to prevent the spread of the virus. So, when these civil authority actions are lifted, that might be a reasonable determination of the end of the period of restoration and the end of coverage. But that's not always the end of the story. In many cases, businesses still have to ramp up and restore their pre-loss income. So just because they're open and operating, they still have to ramp up to get back to their pre-loss income. That's called an extended period of indemnity that's usually provided in policy. That's the triangle on my diagram. That usually goes for 30 to 60 days. So it may provide some relief, but this is sort of what the claim looks like as you're valuing it. And this basic framework, this basic determination of a hypothetical profit versus the actual profit is no different whether you're doing standard business interruption or contingent business interruption that Eric had mentioned. What's different is where the property is actually damaged and the restoration of that property, whose property it is. So the thing about these BI values, business interruption values, they're not directly ascertainable from somebody's financial statements. Although those provide the basis for valuing these claims, even in the rare event of a total suspension, determining that business's hypothetical profit during the period of restoration is an analytical process. It often requires establishing one or more benchmarks for determining what the business's performance would have been. And these benchmarks have to adequately isolate non-covered losses. So in the case of when a physical loss is covered, it's other economic impacts that are unrelated to the physical loss. Those aren't covered, but they have to be accounted for when you're actually trying to value what the payment should be under the policy. Now, as I'll explain later, depending on how litigation or legislative action pans out and what we actually have to consider, whether these benchmarks have to consider the economic losses of COVID-19 on the wider economy will really drive the complexity of these valuations, any of them that go forward. Additionally, the only expenses that are covered are the business's fixed expenses. Those continue whether or not it operates. Often policies provide that also includes payroll expenses just so the business can keep its employees while it's shut down. What this really means is that the forensic expert has to isolate and quantify the variable expenses, those that differ depending on how much what your operational levels are. That's more complicated when in most cases the business isn't completely shuttered, but there's some level of operation because, as Eric pointed out, the insureds have a duty to mitigate. Okay, and documenting those extraordinary expenses is really difficult because they have to be demonstrated that they were incurred to shut down or restart the business, or otherwise serve to minimize or mitigate the suspension of operations. Now, in the latter, the carrier is only going to cover the amount of that expense up to the amount that actually reduce lost income. So these expenses have to be explicit in reducing the lost income. All right, so as we all know, coverage terminations are the name of the game right now, and we're really in limbo waiting for legislation and waiting for litigations to pan out. But that doesn't mean that businesses and carriers shouldn't start the valuation process now in one form or another. Now, delaying and waiting certainly doesn't facilitate the rigorous, well-documented claims that benefit both parties, okay? Trying to reconstruct a loss after the fact is like trying to learn an entire semester before your final. Once in a while it works, but even then you're left saying, why didn't I just study after each class? If you don't start documenting now and you try to reconstruct it, it's going to cost both parties time and money. Carriers, even if you're denying coverage, if you're analyzing the claims that you're getting in to sort of isolate and categorize those that potentially could be covered, understand what the documentation looks like, you're going to be able to handle those claims more expeditiously at a lower burden if it turns out that in large part they should be covered due to either litigation or legislation. Now, mitigation is not only a duty, but it's a win-win for both parties. And unfortunately, it's not a retrospective analysis. For carriers, identifying, communicating, and facilitating potential opportunities for your policyholder to mitigate only serves to reduce your liability. And as I'm going to explain throughout this presentation, the causal analysis that could be required to establish the covered business interruption values could be highly complex in the presence of COVID-19's impacts. So it's better to start now and make sure you have the data that you need to put up these alternative measures and benchmarks that you'll need to determine hypothetical income. So starting the process now is nothing more than adhering to and implementing best practices. The first thing, whether you're business or carrier, is to assemble a team. And the theme here is centralization. You need to have a centralized team that's analyzing the business loss, collecting and retaining documentation, and setting up a standardized, centralized way to retain that documentation. That'll make your claims process smooth for both the business putting it together and the insurer reviewing it. If insurers can signal in some way that the more well-documented claims sort of rise to the top of the pile, it can provide an incentive for businesses to actually take rigorous time and effort to put forth well-documented claims. Another thing that you really need, I think without question, the most important thing is a clear narrative, whether it's verbal or written, about how the loss actually unfolded and occurred. Getting a bunch of tables and numbers doesn't really help anybody. If I'm helping a carrier, I'm still going to advise them to start from the beginning and tell the story. Right now, I'm working on behalf of a carrier, and the policyholder's accountant and I are often bemoaning the fact that the policyholder did not authorize a written narrative of the loss. And we're having to basically reconstruct and understand at each point how the loss just unfolded and how it actually impacted the business. So a useful narrative is a key tool to moving these claims forward expeditiously. Businesses should definitely be establishing new accounts now on their general ledger to track expense and revenue items that are unique to the loss in question. Trying to extract these unique expense and revenue items from standard general ledger accounts that the business normally operates is pretty tedious, about as tedious for me as learning all the one-word named software platforms that my kids are using for virtual classwork. It's not only that, but in large part, if you don't separately track and isolate these expenses and revenues, you tend to miss things. So it only serves both parties. It certainly serves the policyholder to be tracking it, and carriers could be communicating this tip to policyholders at the notice of an initial claim, because having the information well organized only helps the claims be moved along quickly. Now, there's going to be a lot of unique expenses. Of course, decontamination of the virus is one, but I think it shouldn't be surprising that the startup costs of moving to an at-home workforce could be an extra expense, because as Eric has described earlier, continuing operations from an at-home workforce is a form of mitigation. So it's reducing the loss of income because the business is continuing to operate at a temporary location. What I've seen so far in some documentation is about $2,500 to $3,500 per employee to start up. But what we need to know is that people that are already capable of working from home and any pre-existing plans by the business to have already expanded to an at-home workforce shouldn't be covered. That means that appropriate documentation requires company policies on working from home, including expense reimbursements for startup and relevant business plans. And as you can see from this diagram, some of the businesses that are really heavily affected, like leisure and hospitality, they don't have much of a capability, before COVID-19 to be working at home. Whereas if you're talking about a professional services claim or something in the financial sector, roughly 1 out of 2 employees is already able to work from home. So the claims for at-home workforce expenses could be greater for the industries that are trying to catch up. What I've also seen is that if you actually have to try to establish lost income, some of these other sectors are going to have to actually show that working at home with an at-home workforce actually reduced revenue or otherwise reduced productivity to create an income loss. I think that's going to be more of an assertion than something that's quantitative. It's going to be really difficult because there's a lot of data and studies that show at-home workforce are just as productive, if not more productive than working in the office. It really depends on the industry. So like I mentioned earlier, mitigation is key. It's key to both the business and trying to get back on their feet. It's key to the carrier and minimizing their liability. Here are several examples that are listed. These are sort of unique examples because they all pertain to companies that are actually mitigating by changing or bringing in new revenue streams by getting involved in the response to COVID-19. Now, that certainly doesn't, that opportunity is not available for everyone, but I think the key is that it could be just like a restaurant that starts offering takeout orders. That's mitigation. If it didn't do that before, signs up with Grubhub. Finding these cash flow solutions is really a natural reflex for many business owners. They're sort of on top of it. But when it isn't, I think brokers and consultants and even carriers can help to identify and facilitate these opportunities if they're actively communicating. So as I mentioned earlier, determining and establishing BI values, business interruption values, can be really, really difficult in the presence of other economic losses. Because if you look at the left panel here, like sort of a commercial property policy that's traditional, you got to isolate the impact of the physical damage or loss, which is covered, from other economic factors that are affecting the business operation, but are not covered under the policy. So in the case of COVID-19, this could be really difficult because obviously it's had a wide impact on the economy. If you moved all the way to the right under like a pandemic or an all risk policy, well, the pandemic itself is covered. So all the businesses losses, any reduction in income or that you can establish is essentially covered. So the further we move to the right towards an all risk policy, the easier the valuation. The more stringent we are on the left side of my diagram in interpreting physical loss, the more complicated it is going to be because we're going to have to sort out these other economic losses that aren't covered. And I'll give you a few examples of the traditional methods in the next 3 slides and how they may or may not be suitable for doing that. The first and simplest is called the before and after method. That's simply when the but-for income or revenue, whatever metric you're starting with, during the loss period or the period of restoration is the same as it would have been before the loss, either right before the loss or in some period. Now, this is really simple and easy to estimate. The problem is it can't really sort out the difference between other factors and the physical loss. So it's sort of useless in the sense when you have competing factors that are contributing to the business's loss. Another methodology that I think we're going to see a lot of here is called the budget forecast method. Essentially what you're doing is you're saying, look, I've established these forecasts regularly as a business. Here's what I would have produced based on my forecast or what I would have generated. Now here's what I actually generated and there's my loss. Well, the trick there is that there's always a difference between a forecast and an actual realization. And so if companies are going to be putting this up as their sort of substantiation for their business income loss, they're going to need to be providing some historical reference points on that margin of error. It's really different if your forecast misses by 20%, if your actual misses forecast by 20% and you normally miss by 10%, versus if your shortfall in your revenue or your income is only 5%, okay? You're within your normal margin of error. So that sort of analysis is key to establishing a loss. A more complicated but often very useful method is called the yardstick approach, which is essentially where you're measuring your businesses, you're benchmarking your business's income or performance to other unaffected businesses in the same industry, the same market area. They're all affected by general economic conditions. The only thing that's unique to your business, of course, is a physical loss. So this method is really useful for sorting out the physical loss on your business from any reductions in income due to other factors. The problem here, of course, with COVID-19 is that due to its wide economic impact and the fact that many businesses are making business interruption claims, it's really going to be difficult to find a useful benchmark that wasn't also affected by the same losses that are covered, such as under a civil authority coverage claim. So I've just got a few more slides I can wrap up and move to a brief Q&A. I think where we're going to be now with all this uncertainty and complexity with valuation is just making sure you have your ducks in a row and developing the data you need now to develop alternative analytical requirements so you can be nimble depending on how the coverage litigation disputes fall out, how the legislation falls out in terms of whether or not these benchmarks need to include the economic impacts of COVID-19 or whether they should try to isolate those and only cover what is a direct physical loss, however that's interpreted. So getting your documentation in order is key. I think in large part, our traditional analytical methods could be very difficult to implement. I think you might have to rely a lot more on what's called specific analysis, where you're looking at canceled purchase orders or canceled any sort of cancellations, price differences, internal business records that sort of establish that you actually had lost sales, rather than looking at it from an analytical perspective. So keeping that information front and center in your claim is going to be helpful. The last concept is the concept of makeup sales. This is a unique concept in business interruption valuation. These are sales that occur after the period of restoration, so after the property is restored and coverage ends, but that these sales actually relate directly to a sale that was lost during the period of restoration. So I can go through just a few examples here. If you've got a conference at a hotel that was lost because the hotel was shut down, but it rescheduled for some time later, that would be considered a makeup sale, because essentially it is a sale that you would have had during the period of restoration, but that you obtained later on. If you've got a restaurant, for example, with no pre-existing group business or banquet services that starts that service in response to increased demand after the period of restoration, that wouldn't count because those are essentially new demand or new sales, okay? And then there's often gray areas, and we have to try to do some analytics to determine whether those are really makeup sales. Now, this is really important here, I think, in the case of COVID-19. Economists dub a phenomena of massive spending increases following downturns is called pent-up demand. Consumers are essentially making up for lost spending opportunities or making the purchases that they had delayed. And we very, very well see this, especially with travel and leisure, when these shelter-in-place orders are actually lifted. So to the extent they're lifting ends the period of restoration, and there's an increase in spending, that could be an offset to losses. And determining that is pretty non-trivial because we have to show the increase was an extraordinary increase. It was unrelated to a new source of demand or a contraction of supply within the industry. So there's some economic analysis to do, but I think this is going to be front and center in addition to what Eric mentioned about latent contingent business interruption claims. In the interest of time, I won't read my last slide. I think the concept is starting the valuation process now. Certainly if you're a business, you better be doing it now to the extent that you can, because trying to reconstruct it is really a non-starter. And I understand when carriers are denying claims that they're not actually going to be then asking for documentation, but preparing by analyzing the claims that you have in the door, preparing for what the landscape might look like if you have to cover claims because of litigation or because of legislative action is going to make the process smoother in that event. And that's all that I have.
Thank you, Ryan. That was great. Very informative, very helpful. And we also have a few questions for you too. But in the interest of time, I'm going to start with the senator because we had a few questions come in for you, asking more for clarification regarding the funding mechanism for the program, essentially. So if insurers are able to seek reimbursement, again, how does that work? If you could explain that a little bit more, and also if you could add in the context of considering right now how the COVID-19 related shutdowns have impacted the state's budget. Is this actually something that's really feasible given the circumstances right now for the state to be able to provide reimbursements to insurers who may seek those claims?
When a small business owner that has business interruption insurance submits a claim to an insurance company, the insurance company would pay out those claims and then they would turn around and submit those claims as reimbursement from state government. And as I noted earlier, post-pandemic, the Division of Insurance would assess the entire insurance industry to recoup that money and sort of spread the risk. On the state revenue front, I mean, there's no doubt that we have a significant drop in state revenues. It's estimated to be probably around $5 billion for the FY21 budget, which the legislature is supposed to begin working on soon. So that certainly is a challenge. Although I would point out again is that if we don't find a way to get restaurants to reopen once the pandemic is over, that's going to lead to a permanent loss of jobs and revenue for the Commonwealth in general. Because the federal government can obviously deficit spend, unlike the state government, myself and Representative Nika Eligardo, Jack Lewis, and Senator Nick Collins just sent out a letter, a sign-on letter asking the federal delegation to consider the next round of stimulus to provide funding either to be a backstop to business interruption insurance or to pass its own version of that to cover claims during the pandemic. So we recognize again it's a challenging bill, but it's bringing up all this good discussion, and just a reminder that we need to find a way to help the restaurant industry. Massachusetts has among the strongest in the country, so we really need to make sure it survives.
Okay, and have you heard any responses yet to the letter that you sent from our federal delegation?
It was actually just sent this morning.
Okay.
We sent it out last week and we got sign on, so it's sent out this morning.
Can you explain what's unique about COVID-19 for contingent business interruption losses?
I think normally what you see with contingent business interruption losses is that the company has to try to mitigate their loss, so they often try to look to another supplier. Like Eric mentioned, the component part in a larger manufacturing process. Hopefully your supply chain is diverse enough to where you have the flexibility to increase purchases from other suppliers, where one supplier may have had damage at their property and they can't now provide the parts. In the case of COVID-19, what's unique is just the wide impact, right? I mean, you're talking about one property that might be impacted in one business's supply chain. Here, your economic impacts are such that it's spread over the entire globe. So not only are we going to see global, but domestic supply chain issues. There may not be alternative suppliers to go through. There may not be another additional capacity from existing suppliers. Now, in some cases, it could be that some suppliers are hurting and they do have additional capacity. So I think there's a lot more questions about the availability of mitigation with the wider impact of COVID-19 is the way to put it.
The questioner says, I was wondering if you have a sense of how long these claims will take once submitted, especially given the large numbers of claims.
Well, I think, it's sort of unique actually that what I have been seeing is, claims and then followed by an immediate denial, because the insurers right now are focusing pretty exclusively on the coverage issue. And in some cases, I've heard instances where policyholders are actually receiving denial letters even before they file any sort of claim. So I think in terms of actually going through the entire claims process, I mean, we have this sort of major roadblock of the coverage question. And I don't think you're going to see advancement with respect to individual claims as a result of that issue. That being said, as Ryan has alluded to, this doesn't mean that both policyholders and insureds shouldn't be doing the groundwork to prepare themselves in the event that the coverage issue is sort of overcome and we find ourselves having coverage. And I think that would likely apply both within the context of insurers paying out claims or potentially a government type of program that, whether on a federal or state level, they'll still need these valuation questions and need information submitted. So I think it's sort of a two-part issue. The coverage items for the time being, I think are going to take a while to play out with respect to preparing for claims. Do what you can do now to get yourself ready.
I just want to add one thing. I just in talking with some of the carriers, they're seeing volumes like they've never seen before. I've talked to one that has 600 or 700 business interruption claims, which in the past, they deal with something on the order of maybe 50 to 60 claims during this period. So I think their bandwidth will be highly challenged if these claims do have coverage and go forward. So I'd expect it to take much longer than a traditional claim, unless those bandwidth issues are overcome in the interim. And that would only, again, be assuming that the claims are covered and go forward.
Before I let we wrap it up here, I'd like to just ask our panelists if they could offer a few final words for their thoughts regarding the future of business interruption insurance in the wake of COVID-19.
I'm just hearing from so many, businesses that whether it's business interruption insurance or some other, legislative or government effort, we really need to think strategically now about how to support small businesses, because I'm just hearing from so many that aren't sure if they're ever going to come back. And that's going to be a very different society, especially if so many of the restaurants that really I think is part of the culture of Massachusetts goes away. So I'd really encourage people, however you feel about this specific bill, reach out to your legislators to ask, what's being done to sort of get all aspects of society, including the economy and businesses, to get back to functioning once the pandemic is over.
I think that the future is going to be murky for at least the short term, because we're going to see this litigation on the coverage end continue for quite a while. But my sort of personal mantra is control what you can control. And so, the overview that I had presented before was, again, very much a broad brush. I think each individual insurer, each individual policy requires individualized analysis to really understand what options may exist for both policyholders and on the insurance front as well. And, to the extent that that is something that needs to be done, I myself can certainly help and our office can help. But I think it's something that recognize that we're going to sort of stand back and watch what happens in the courts with these current claims. But from an individual perspective, that we really need individualized analysis, and I can't provide that now.
I think that, again, echoing what Eric said, obviously the claims, the coverage issues are going to take a while to sort out. I think we're going to see some of the more complex business valuations that we've seen in the past. I mean, every time there's a natural disaster, it's always difficult to sort out sort of what the but-for world would have been like when you're trying to sort out a physical loss of some business that was in a disaster area. Well, the disaster area here, if these, interpreting it as civil authority, and the shutdowns that are required in the shelter in place is the whole country. So I think depending on how that shakes out, there's going to be really a lot more complex valuation that's typically needed. So I think you'll see a different array of experts trying to help policyholders and carriers sort that out. I don't see class actions being the future, at least in the traditional sense where I deal with them as an economist on common impact and damages. I think that the proof will be individualized, as Eric pointed out. I think it's a really good point. I agree with that. But yeah, I just think you're going to see a lot more complex valuation issues here, and you may see a lot more businesses in the future, shying away from, in addition to business interruption insurance, procuring pandemic risk insurance.
Mm-hmm.
I think you'll see a shift to that sort of policy. The businesses that are sophisticated can do that, and perhaps the industry will be able to. I don't know what the industry is going to offer in terms of traditional business income policies or business interruption policies, but I think they'll offer that product that's already existing to more policyholders, more brokers. Brokers will be more apt to offer that coverage, I believe.
Thank you. And with that, I think that concludes our program. I'd like to thank everyone here for joining us, and definitely all of our panelists for being here and providing your expertise. We are putting up some contact information if anyone would like to take that down. And you can also feel welcome to contact our office. We are always happy to help. Again, I'm Chanel Brown, Director of Government Affairs at CMBG3 Law, and this concludes our program.